Good afternoon. Myself, Dr. Somnath Roy. Today I am going to give an idea regarding directive principles of state policy as laid down in the Constitution of India. We know that Constitution of India, it has been divided into several parts, into 22 parts and 12 schedules. This Constitution of India, it is the supreme law of our country. It is the highest law of our country, and all the other laws which are existing in our country are subordinate to the Constitution. All the laws which are existing in our country are subordinate to the Constitution, and they are having their source in the Constitution itself. So, if any law which is against the Constitution, which is against the very spirit of the Constitution, that particular law will be ultra vires the Constitution, and it would be the status of that particular law would be void. It may be for the case of a particular provision of the law, or it may be for the entire law also. If it is seen that a particular law in its entirety, or if any part of a particular law is going against the very notion of the Constitution, very spirit of the Constitution, or against any of the provisions of the Constitution, then that particular law would be considered to be ultra vires the Constitution, and hence the status of that particular law or that portion of that particular law would be void. Now, I'm going into the concept of directive principle of state policy as laid down in Part 4 of the Constitution. So we know, or we will see, that Part 4 of the Constitution has laid down or has given certain directives, certain dictates, or certain mandates. So who has given these mandates, or who has given these directives? These directives have been given by the Constitution itself. And to whom these directives have been given? These directives have been given to the state. And these dictates or these mandates are to be kept in mind by the state while making laws. Right? Now, coming to the concept of state. So, the provisions regarding directive principles of state policy as contained in Part 4 of the Constitution are there in Articles 36 to 51 of the Constitution. Now, the directives have been given by the Constitution and to the state, and the state shall keep in its mind these directives. Now, I was saying about the concept of state. The meaning of the term state has been, or the term state has been defined in Article 12 of the Constitution, and Article 12 is very much there in Part 3 of the Constitution. And for the purpose of Part 4 also, this will be having the meaning of the term state will be having the same meaning as given to it by Article 12 of the Constitution. Why I am saying this? Because Article 36 has specifically stated that for the purpose of this part, that is Part 4, the meaning of the term state shall be as what has been defined in Part 3, that is in Article 12 of the Constitution. And briefly, we can say that if we analyze the provisions laid down in Article 12, there we will find that the term state includes the legislature and the executive of both the sets of governments. I mean the state governments as well as the central government. So the legislature and the executive wing of the state government as well as the central government are included within the meaning of the term state. Now, apart from these two wings of the government, some local authorities are there, some other authorities are there which are run and which are controlled by the government. Now, coming to the concept of local authorities or other authorities, we will find that there are several decisions of the Apex Court whereby the Supreme Court has stated or has included several bodies or several organizations within the concept of state. So the municipalities, electricity boards, panchayats, then cricket board, then universities, then colleges, all these, or state Steel Authority of India Limited, all these are coming within the concept of state by virtue of several decisions of the Supreme Court. So by virtue of different decisions of the Supreme Court, we can come to know that several bodies, several authorities, several institutions, several organizations have been included within the meaning of the term other authorities under Article 12 of the Constitution, thereby giving the status of state to them. Hence, against those authorities also, fundamental rights can be enforced. Because we know that usually the fundamental rights, as laid down in Part 3 of the Constitution, are enforceable against a state, which is the meaning of Article 12. And it is specifically mentioned in Article 36 of the Constitution that the term state, as it will be appearing in Part 4 of the Constitution, shall be having the same meaning as defined in Article 12 of the Constitution. So what we have read, the meaning of the term state in Article 12 for the purpose of Part 3, the same meaning we will have to take into account while we will be studying the provisions contained in Part 4 of the Constitution. Now, the directive principles of state policies, I have already stated that these are nothing but certain dictates of the mandates which are given by the Constitution to the state. But these directives are not enforceable in any court of law, unlike fundamental rights. We know that fundamental rights are enforceable. So if any of the fundamental rights is infringed of an individual or of any citizen, as the case may be, then the person concerned can approach the appropriate court for the purpose of getting remedy. But it is not so in case of directive principles of state policy. If a directive principle of state policy is not followed, or if it is not obeyed, then the person concerned cannot approach the court for the purpose of getting remedy. Then where lies the utility of keeping these directives in the Constitution? Because it is specifically mentioned in Article 37 of the Constitution that though it is not enforceable in any court of law, yet these directives are equally fundamental in the governance of our country. So these directives or these principles cannot be neglected, cannot be ignored. And for this purpose, we can say that several directives have been given the status of rights. Several directives have been implemented by making legislation by virtue of that particular directive. Say for an instance, in Article 42 we will find just and humane condition of work and maternity benefit. It is one of the directive principles of state policy. So it is a directive principle of state policy as stated in Article 42 of the Constitution. And with a view to implement this directive principle as stated in Article 42, the Maternity Benefit Act has been enacted by our Parliament. So when we are saying that an act has been enacted for the purpose of implementing a directive, we can say that the directive has been given the status of right, because whenever a law has been enacted, by virtue of that particular law, it becomes a right of certain categories of persons to get the benefits of that particular law. Here in this case, we know that for the purpose of maternity benefit, it is not applicable for all categories of women, but it is applicable for certain categories of women, that is the women who are carrying child or who has delivered child. A period of leave will be granted to her if she is employed without deducting any sort of salary, and her employment also will not, she will not also lose her job even. So this is, in other words, we can say that it forms the right of those categories of women to enjoy the rights which are stated in the Maternity Benefit Act. So here we can say that the directive principle of state policy has been given the status of right in this manner. In this way, we will find that several directives have been given the status of right by enacting several legislations for the purpose of implementing those directives. Say for an instance, equal pay for equal work. It is a directive principle of state policy. And with a view to implement this directive, the Equal Remuneration Act has been enacted in 1976. Then preservation and protection of environment, as laid down in Article 48, capital A of the Constitution. For the purpose of implementing this directive, the Environment Protection Act 1986 has been enacted. So far as the educational rights of the children up to the age of 14 years is concerned, we will find that previously it was a directive principle and it has been given the status of fundamental right by virtue of Article 21 capital A. So before the coming of Article 21 capital A by virtue of the 86th Amendment in the year 2002, we will find that within the meaning of the term right to life under Article 21, right to education has been recognized by our apex judiciary. In the case of say Mohini Jain, that is capitation fee case. In the case of Unni Krishnan also it has been recognized. But it was recognized as part of fundamental right under within the meaning of the term life under Article 21 of the Constitution. But now, by 86th Amendment of the Constitution in 2002, the directive which was contained in Article 45 has been given the status of fundamental right directly by amending the Constitution. So, we can recap by saying that there are several directives as contained in Part 4 of the Constitution. These directives are nothing but certain principles or policies which have been given by the Constitution to the state, and the state shall keep in its mind while making any law or while formulating any policy. The directive principles of state policies are not enforceable in any court of law, but the directive principles of state policies are definitely fundamental in the governance of our country. Okay, thank you.